number 24, Cutaia versus a Board of Managers of 160/170 Varick Street Condominium. Counsel?
Good afternoon, Your Honors. May it please the Court, my name is Michael Kazores from the Law Office of James J. Toomey, and I represent Trinity Church in Machili. I respectfully request 3 minutes for rebuttal.
You may have 3 minutes, sir.
Thank you, Your Honor.
You're welcome.
On this appeal, we're simply asking this Court to apply its own precedent in Nazario and to reverse the First Department to bring it in conformity with the other 3 appellate departments and with this Court's guidance in Nazario. Plaintiff is not entitled to summary judgment on his Labor Law 240 sub 1 claim, absent proof of a statutory violation and that the violation was a proximate cause of his injuries.
But counsel, up here.
Yes.
I struggle with this because let's just assume for this question that placing the ladder against the wall in this position is wrong, right? Can't do it, it's not open, it's not locked. And I take your point on causation, but why isn't the response to that, this is partial summary judgment and you prove that up in damages?
It's not partial summary judgment because the improper placement of the ladder would be irrelevant if it was not the proximate cause of the fall. If the electric shock was the proximate cause, which the Supreme Court found that it was, and awarded the plaintiff summary judgment on his 241 sub 6 claim, which we're not challenging, then whether the ladder was improperly placed or not, if the ladder didn't move or didn't fall or was not defective, there's no proximate cause.
But could the injuries have been different if the ladder was being used the way it should have been used, even with the electric shock?
Well, Your Honor, I think we get into speculation at that point.
But does you get into a jury trial on whether or not that caused any of the damage?
I think this is an issue for the jury. Recently, the First Department decided another case, Gowden, 188 AD 3rd, 596, where they cited the Vukovic case to grant summary judgment for the plaintiff when he fell off a scaffold under very similar circumstances here. So before it was a ladder wasn't sufficient, and now a scaffold's not sufficient. It's our position that the First Department or certain panels of the First Department are using Vukovic to rubber stamp summary judgments in favor of plaintiffs on electrical shock cases without having them show a statutory violation and that the violation was a proximate cause of the injuries. To the extent that
I guess my question is, can you say here, again, assume you have a statutory violation, your question's proximate cause, you got summary judgment on statutory violation, why can't you let the jury figure out proximate cause? Because you don't have any injuries proved yet, right?
I don't think we get to summary judgment on 240 unless there's been a proven violation and proven proximate cause. I think that all has to wait for a jury. To the extent that my written or oral arguments fall short here, I would refer the court to Justice Tom's dissent in the case below and in his reluctant concurring opinion in Nazario as our position. I could not have stated it any better than Justice Tom did below.
It seems one of the things we may have to grapple with here, maybe not, but is the distinguishing of Nazario, and if Nazario can't be distinguished, then you would argue that you would be successful. Is that right?
Yes.
All right, and if it can be distinguished, then what will be the basis of the distinguishment? But before we do that, can we analytically just take a step back a second and say, don't we have to really answer the question of the adequacy of the safety device in the first instance is what 241, not 241.6, but 241 has to look at. And that responsibility for providing the adequate safety device in the first instance would be your client's responsibility. You would agree with that premise?
Under the statute, yes.
Sure, under the statute. It's pretty straightforward, basic labor law stuff. that being the case, wouldn't it, you have to be protected from both, you have to provide a safe work environment, a safe way to do it. So if the device that's provided for you to work in an elevated setting on a particular location that could result in electrical shock, doesn't it have to both protect you from working in an elevated 241 circumstance and also from the electrical shock, which means that the device that you're on, whether it's a scaffold or a platform, whatever, has to be adequately grounded so that you won't get shocked. And in this instance, the question is whether or not that safety device in the first instance was adequate. Wouldn't that precede any other analysis? And that seems, that it seems kind of a straightforward analysis.
Is Your Honor's question whether the safety device itself was required to anticipate that the worker would
Well, no, it's
receive
not
an
a question of
electric shock?
anticipation. You tell a guy to go up there and work on an electrical device and you're elevated. So because you're elevated, he has to be able to work safely. That means you don't fall off and you don't get shocked or damaged by electricity. Just in the same way as if you were working on an elevated device and you had to perform another type of activity where the activity itself could hurt you. Wouldn't we first have to look at the adequacy of the safety device, which would here be the ladder? And the ladder had to protect you from both falling and from falling as a result of your shock. Wouldn't it have to protect you?
Your Honor, respectfully, I think you misspoke when you said that he was there to work on an electrical situation. He was a
Go ahead.
plumber, and it was not anticipated that there were any live electrical wires up there. It was simply an accident that one of the caps on the wires fell off and happened to make contact with one of the pipes.
No, I understand that.
Right.
I'm not questioning your recitation of the facts. I'm just wondering if the safety device has to protect you from working around in an environment where you could be injured in various ways. And one of them is through electrical shock and you're in an elevated environment.
I don't think so, Your Honor, because...
And why is that?
Because the safety device itself is to provide adequate protection and access to the work area.
Mm-hmm.
Now, certainly it has to be safe, but the law in this state and set forth by this court isn't that owners and general contractors have to anticipate every single possible danger that a worker may encounter on a work site.
So let's assume for a second that, that this ladder, that there's, at least there's a question about whether the ladder was appropriate. Do you think the plaintiff has to show that there was another enumerated safety device that would have made that ladder safe?
I don't think he has to do that if he can show under the case law, as instructed by this court and all the other departments, that if the ladder failed him as a result of the electric shock, and all the other cases where summary judgment was affirmed for plaintiffs in the 240 case, it was demonstrated that the ladder itself did not provide the proper protection because it collapsed or slipped or was otherwise defective. Here in this case, there's no evidence that the ladder fell or slipped or was defective in any way.
Does it matter whether the ladder wouldn't fit in the open position in that space versus whether it wouldn't reach where he needed to get? Does that make a difference?
I don't think it does make a difference because he was using the ladder for 5 to 15 minutes before his accident. He had no problem reaching the workspace. Now, granted, he should not have set up the ladder in that position, but the ladder itself and the positioning of the ladder was not the proximate cause of the accident. It was the electric shock.
So let me ask this then. Are you saying that the Court of Appeals, well, let me ask you this. Can you point to something where the Court of Appeals has ever suggested that all elevated falls following an electrical shock are carved out of the protections of the statute?
Absolutely not. That was touched upon.
Is there some form of an electrical shock exception that you're arguing for?
Absolutely not. And
So shouldn't the safety device then protect you from an electrical shock if you're working around electricity in an elevated situation?
well, what device would that be?
Well, you ground it.
You ground the...
I mean, probably none of us here are electricians, but my minimal understanding of it, you just simply have a grounded device if you're working in that.
Would that require us to overrule Nazario? I mean, wasn't Nazario a shock case where the ladder was properly used and we said, no, you don't have strict liability there?
It would not require you to overrule
No,
Nazario.
I'm saying would Judge Fahey's point require us to overrule?
Oh, yes,
Nazario?
I think it would. I think, you know, I'm not an electrician either. I don't think grounding the ladder would have provided the protection to the plaintiff
But
because...
here, the difference with Nazario, to me, is not, do we need a rule that says anytime you go up on a ladder, you have to be protected from electric shock? It's, does it make a difference that this ladder was not open and locked as an A-frame? Is that the difference that gets you out of Nazario?
I do not think so, because if the plaintiff had testified that the ladder fell, and part of the reason was because I couldn't access my work area and I had to fold it up, and a proper ladder wasn't provided, and that's why I fell, then no, that would be an easy 240 case.
Well,
for the
doesn't he say
plaintiff.
part of that? Doesn't he say, I couldn't use the ladder in its open and locked position, I had to fold it and put it against the wall? He says that part of it, right?
Correct.
And there is evidence that the ladder was sideways after the accident on the floor, no?
There's evidence that a ladder was sideways on the floor, not necessarily the ladder. There's testimony from Mr. Renna that he doesn't recall if he saw more than one ladder in the room. He testified that he saw a wooden 8-foot A-frame ladder on the floor, but the plaintiff testified he was using a 10-foot blue fiberglass ladder. So the ladder that Mr. Renner saw on the floor was not the same ladder that the plaintiff was using if we believe plaintiff's own testimony as to what ladder
Let me
he was
ask you, other than going to his credibility, what is the point of that?
The point is that plaintiff has not met his prima facie burden to show that the ladder failed, that there was any...
Well, I'm not understanding why the fact that he calls it the ladder's made out of one kind of material and someone speculates made out of another kind of material. Why is that
It's that it
mattering
was two different-
to the ladder that's actually next to him shortly after he's crying out?
Well, it wasn't next to him. Mr. Renner didn't see the plaintiff until the plaintiff was already outside of the room where the accident happened. What Mr. Renner saw was a ladder lying on the floor. There were other ladders, or could have been other ladders in the room, and that ladder on the floor might not have been the ladder that the plaintiff was using. And if-
Again, I'm sorry, perhaps I'm not being so clear. Why would that matter if his testimony is, I'm working on a ladder, you seem to not dispute that, and then he says, I got electrocuted, I'm on the ground. I don't remember how that all happened.
Well, the fact that there's a ladder on the ground is
Yeah.
some evidence that perhaps that was the ladder he was using and maybe it fell over. But there's also
Yeah,
evidence...
but I thought your position is that nothing wrong with the ladder.
Our position is that we don't know if the ladder that plaintiff was using at the time of his accident failed him in any way. We don't know if it fell over.
But again, this distinction of what material it was made out of, I'm not really appreciating why
It's-
that goes to that
It's
question. Let me put it that
because,
way.
it's because the ladder that Mr. Renna saw on the floor,
Yes.
which everyone in this case, the lawyers throughout the depositions were presuming
Yes.
was the ladder that the plaintiff was using and that it was on the floor because it collapsed, was an 8-foot wooden A-frame ladder. Plaintiff has denied using a wooden 8-foot ladder as he was doing his work. So that raises an issue of fact as to whether or not the ladder Mr. Renna saw on the floor was the ladder, or if it was another ladder that was standing erect against a wall that hadn't moved.
We do know, though, that the ladder provided to him was not an appropriate safety device for the job. Is that fair?
I would agree with that. Yeah. But we don't get to the
Understand.
point of that being relevant unless that ladder failed him. And in this instance, there's a question of fact as to whether that ladder failed him.
Thank you, counsel. Counsel?
Thank you.
Good afternoon, Your Honor. My name is Louis Grandelli. I'm the attorney for the plaintiff, Michael Cutaia. Just with respect to the discussion of the ladder, the only evidence that we have in the record is that there was one ladder in that room. I asked all the witnesses, and no one recalls seeing any ladder other than the A-frame ladder that Michael Cutaia was using and that was found under the exposed wire in the pipes by the defendant's project manager
Except
immediately
that
after
that's not the ladder that the plaintiff testified he was using, and it's certainly possible that nobody was particularly paying attention to whether there was another ladder in the room or, you know, if it was standing up against the wall. or
Well,
what was-
let me just go through this space with you. This is
Can you
was
address
this-
why it matters? I'm still, you could obviously answer Judge Stein, but I still don't understand why it matters. I may not be appreciating the argument.
It's an A-frame ladder either way, whether it's fiberglass or whether it's wooden. There's only one ladder in that room. This was not a room that was used for storage. And there was one thing that I missed in my brief. I should have pointed out to you. There's testimony from the electrical contractor's foreman, George Lopez, in pages 1433 and 1434 of the record, where he goes there the day after the incident, and he says this room is a wide-open room, concrete floor, 4 walls, pipes and electricity in the ceiling. It wasn't a room that was used for storage. There was no tools or no other ladders. Michael Cutaia was using one ladder, the same A-frame ladder, all day. He said he regularly used that ladder, and he was able to use it that entire day in its intended fashion by opening it up, engaging its safety mechanism, and performing different tasks throughout the room.
Is there any indication in the record as to what the size of the space was? I can see how you could read the plaintiff's testimony in a couple of different ways, and, you know, and some choose to read it to say that he couldn't reach the spot, and some would read it as saying without putting it up against the wall, and some people were saying that there wasn't room to get to the area he was working to open it up and lock it. So,
So let me address that. So the room is intended to be a men's bathroom with 2 toilets, 2 sinks, and a urinal. But at the time of the incident, Cutaia's uncontested testimony is just the roughing for the plumbing. There's no stalls, there's no urinals, there's nothing like that.
okay, but that doesn't, for example, tell me the width or how they were.
I will.
Because, you know, I ask because, you know, I have 2 bathrooms in my home, and they have the same fixtures, but they're very different sizes.
So this is the pages I just mentioned. George Lopez's testimony, pages 1433 and 1434. They ask him to estimate the size of the room. He goes 10 by 25. And that's consistent with the size of any bathroom that contains urinals and toilets and 2 sinks. But again, it was a wide open area. There's zero testimony anywhere in this record that there was any partitions or anything in that room other than things I mentioned. And it was only for this particular task after lunch when Cutaia said, and this is different than any case they said, I tried to open the ladder. I did the best I could. I tried to position it where I could get to the pipes. So this particular area was above the 10-foot wall, but it was over. And if you look at his testimony on pages 499 to 500, right in that area, he says the pipes were in front of me. So if you have an A-frame ladder like this and the worker's on the far side, he can't reach over the wall because he's on the far side with an A-frame ladder. So it was only after attempting to do that that he folded the ladder, because there was no other way for him to use both of his hands to do the work that was
Okay, but
necessary.
for example, does that answer the question for us, which I didn't see particularly answered by anyone, as to whether alternative safety devices such as the scaffolding, the man lift,
Yeah.
would be able to be placed in that area to make it safer for him?
Yes,
to
so
do that work?
our expert reviewed all the testimony in the record, and all the evidence that you have in the record. And what he said, for this particular task, due to the nature of the work, and considering the location of where it was being done, that a Baker scaffold or lift, something with a secure platform or rails, were the appropriate device for this work. And had they been provided, even with the shock, he would not have fallen over the side.
I don't-
And that's similar to the Barretto case from this court.
Did he inspect the area? Was he there?
No, he
Okay.
did not do a physical inspection.
So the question is what would be his foundation for saying, I mean, I can see him saying, sure, if he was on a lift or if he was on a scaffold, obviously that would make it safer, but how would he know that that was possible in that space?
Well, a few reasons. Well, there's two different concepts. So first of all, can you fit a Baker scaffold or lift? It was not a confined area. Scaffolding can be assembled and disassembled very easily. Goes through any door well, you can get scaffolding in, and it can be assembled, and it provides a safe platform with rails. And he says if he had been on such a device, even with that shock, he would not have gone over the rails. He would have been protected from the elevated height danger that occurred in this case, which necessitated 5 operations. Same thing with a man lift. A man lift,
Well, did he address if that was the case, even if he, I know this is another question, but in my mind, a possible question, in fact, as to whether if he was thrown off by the electrical shock, if
So-
it was enough to throw him off, would a narrow scaffold like that, would it have prevented his fall? Does the expert actually talk about
well,
that?
first of all, let me say, a man lift also, you can get a portable man lift. They're easily found. You get like 2.5 feet by like 5 feet. They can go through any doorway. So a man lift is very similar to a scaffold with a platform and rails. What you're saying, Your Honor, I think, is you're getting to the thrust of the electricity, and the dissent in this case saying that electrical shocks have been known to thrust people across the room. There's no evidence that that's what occurred in this case.
That to me goes back to this causation issue. And I think in a way, this lift and the scaffolding, I mean, in Nazario, we didn't say you have an A-frame ladder, you got shocked, you got knocked off, you should have had a lift, or you should have had scaffolding. That's not the rule. So it comes back to me is there a causation difference between leaning this ladder up against the wall and a locked A-frame? Because the locked A-frame, we decided already in Nazario. So I think, what if instead of, we had the exact same facts here, but instead of he gets shocked and winds up on the ground, the entire floor just collapses through some structural floor, and he falls and lands in the floor below. Would you have the same strict liability because you could have tacked him onto the wall? I mean, you have the ladder leaning against the wall, the floor collapses, he falls down. Would you have strict liability in that case?
We have strict liability in this issue because this ladder was not open and locked.
Not this.
I'm
My
trying to understand the hypothetical, Your Honor. I'm sorry.
So, same facts here, he leans the ladder against the
Yeah.
wall, he's working up there, but instead of getting shocked, the floor collapses.
Okay.
And he falls down because the floor collapses, and he's injured from the fall. So would you have strict liability in that case? Because you lean the ladder against the wall, right? You shouldn't do that, and you shouldn't work on that ladder.
Under that hypothetical, even if he was on an open A-frame ladder, the ladder would have fallen, whether it was closed or
So
open.
isn't that the issue of fact here that has to go to the jury?
But that's not the case that's in front of us. The case in front of us is he's dealing with tasks that he's performing in the ceiling, which includes using both of his hands to cut pipes. Where there is electricity in the ceiling, he has to solder with hand tools. He can burn himself. He can sneeze. Anything can happen while he's on that unsecured and unsupported ladder.
Is there a difference between what would happen when this happens in an unsecured ladder and a secured ladder? That's the similarity in my hypothetical, because clearly in my hypothetical, there is not. You're going to go.
If he's using a secure ladder, A-frame ladder in an open position, then he's using it in an intended fashion, and that would be a question of fact under Nazario as to whether or not it was an adequate safety device. But that is not the facts here. In this case, one thing that hasn't been spoken about is our expert affidavit not only said that a Baker scaffold or lift was necessary for this work and would have prevented this accident from happening, but he also said even to the extent that a ladder was used, a safety belt or a harness would have prevented Cutaia from hitting the floor. The defendants had those papers, and all they submitted in opposition was an affidavit from their project manager saying, we didn't provide any tools, we didn't provide any equipment, we had no obligation. Nowhere in that affidavit from their project manager that was submitted in opposition to my motion did they controvert the plaintiff's expert testimony at all.
In Nazario, if you had had an affidavit like that, it would have come out differently?
Again, it's a hypothetical. I wouldn't know what would be in that affidavit, but in this case, the affidavit was uncontroverted. And in Blake, this court said that once the plaintiff makes a prima facie showing of 240 violation, the burden shifts to the defendants to raise evidence showing that there's an issue of fact as to whether the ladder or the device was inadequate, or whether the plaintiff's conduct was the sole proximate cause of the incident. And the defendants have not proffered anything to contest the plaintiff's expert's affidavit in this case. They haven't shown that this ladder could be used in its intended fashion at all. It's completely distinguishable from Nazario and from Blake. Blake, the holding in that case, was really sustaining a jury's verdict showing that the ladder wasn't being used as intended because the worker didn't recall if he locked the extension clips in place when he ascended the ladder, leaving a jury evidence to find that it was completely the sole proximate cause of the incident was the plaintiff's conduct.
It can't be just not being used as intended because, in my hypothetical, the ladder wasn't being used as intended either. And you're not going to recover if the floor collapses, right? So the standard isn't the ladder was being used in a way it's not intended. That's the same. So what's the difference from my hypothetical to yours? It's that he's working on something related to where he's actually working that happens?
Your Honor, I'm just, like, of all the cases, and I've cited, we've gone through 100 cases, there's no real cases that I recall where the floor collapsing and considering whether or not that's an elevated height danger. So it's very hard for me to really articulate
But he falls.
what
I
the
mean,
argument would be under those circumstances, because I wouldn't know
He
the facts in
falls.
that case.
I mean, I'm on a ladder and I fall. The ladder's not being used the right way. So you have to look at what caused the fall, is my point.
Well-
In this hypothetical, it's the floor collapses, but I fall off a ladder that's not being used the right way.
Well, if you had an expert affidavit in that case, that a safety belt or a harness should have been used to protect the worker from falling to the ground, then even with the floor collapsing, the plaintiff would have been protected from an elevated height danger.
So that means that anytime you fall off a ladder, no matter what the cause, you could have secured yourself in some way to a wall or a ceiling or something, you're going to have strict liability. This is really a ladder rule.
Not necessarily. If a ladder is being used like Nazario, it's an intended fashion.
But if you would have,
don't always
if
need
that
a safety belt or a harness.
In
Under this court's rules.
Nazario, if he had been harnessed to the ceiling, he wouldn't have fallen. So under your theory, if I could get an expert to come in Nazario and say, if I harness this guy, plaintiff, to the ceiling, he wouldn't have fallen, I get strict liability.
Your Honor, whether or not, Nazario obviously did not produce an expert affidavit, whether this court ruled differently, if they had uncontroverted expert testimony that a safety device, a personal fall arrest system was necessary, that would be for this court to decide. It could just be evidence for the plaintiff to a jury if you decide it's a question of fact. But again, that's not what we have in front of us. But in this case, under this set of facts, we have an expert saying a safety belt or a harness would have prevented the plaintiff from falling to the ground, and we have nothing from the defendants to rebut that. So they did not sustain their burden of rebutting the plaintiff's prima facie proof.
Over here, sorry, hello, hi, counsel.
Counsel, Judge
Coun-
Rivera has a
I'm sorry.
question.
It's very hard to see all of us, I know. Under Judge Garcia's hypothetical, one could not even be working and fall through the floor. And it's not related to the work in that particular example. You might be on the work site, right? But you could be on a lunch break, just standing there when the floor collapses, floor
Yes.
collapses, right?
Yes.
I thought your point was about the ladder and the connection of the ladder to the injury.
Yes, that if the ladder had not collapsed, which it did, the only evidence you have in this case is that there was one ladder in the room and it fell to the floor at the same time as him. Even though he didn't recall, the ladder didn't fall on its own. It had to have fallen at the time he fell. So even though he didn't recall what happened, he crawled out. This court has said in Felker and in Gordon, the plaintiff need not recount the precise manner in which the accident happened.
Can there be more than one proximate cause under the labor law?
Yes, and in Gordon, this case, this court had a case where a worker was up on a ladder using a defective sandblaster, and in that case, the cause of injuries was partially due to the defective sandblaster and also due to the ladder failing in its core purpose to protect the plaintiff from falling to the ground. So there's two
Isn't that,
proximate causes.
don't we
in court.
have, one of the problems, I think, with this particular line of cases, and it's an analytical problem of a dual risk that a worker confronts in a particular situation. And I think it's difficult for the court struggling with it now, and the members of the bar are also, I think, struggling with where we're going on this. And you have to look back at, I think, a line of cases starting with Felker, which is a ladder case, going forward, and how to deal with this dual risk problem. And I'm not sure that this case will necessarily resolve it, but Judge Rivera's point is particularly important, because when you have a dual risk situation, what you have is a situation where there can be more than one proximate cause of an injury. And here we have a possibility there are two proximate causes of an injury. And I think we got to, in some ways, and both of you can comment on this if you want, we've got to go back and look at the basics. And the basics are the proximate cause isn't the only cause of an injury, but was it a substantial factor in causing those injuries? So you could have a dual risk situation where the failure of the ladder could cause the injury, and also the electrical shock can be a substantial factor. And they're both substantial factors that could individually cause an injury or together cause an injury. And it's a difficult thing. It's really hard to even fault anybody. It's just a difficult thing to disentangle those things in the context of strict liability. Not that I know the answer, but hopefully you will provide us with an opportunity to write on it.
Yeah, well, under this court's cases, we have to show that the violation of 240 was a contributing cause to the incident. We don't have to rule out any other causes.
Well,
And Felker, Your Honor, is materially indistinguishable. Felker was using a ladder all day with no
The
incident.
problem you have, though, is Nazario comes in the way, and so Judge Garcia correctly points out that it is such a recent case, you're really in the land of distinguishing the case, not overruling it. And the problem that you had could be either one of those substantial factors. So I can see problems with both arguments, I guess is what I'm saying here.
Thank you, counsel.
Okay.
Counsel, your rebuttal?
Your Honors, it's our position that the plaintiff didn't even get to the point of making out a prima facie case.
Why wasn't there enough to show prima facie that the ladder fell or failed? What's missing?
Because there's no sufficient evidence, and there's disputed evidence as to whether or not the ladder that the plaintiff was using fell or collapsed at all. Mr. Grandelli said that the evidence is undisputed that there was only one ladder in the room. That's simply incorrect. Page 501 of the appendix, Mr. Renna says that there could have been other ladders in the room, but he saw the wooden ladder on the floor. Page 507 of the appendix, Mr. Renna says other ladders may have been upright, but he doesn't recall. Mr. Renna says that Mr. Alonzo's version that he gave to him of the plaintiff's accident was based on an assumption, and that's page 635 of the appendix. The witness that told Mr. Renna that what the ladder was that the plaintiff was using at the time of the accident, Mr. Alonzo, he wasn't even in the room at the time of the accident. He told Mr. Renna that it was based on an assumption. We can't give summary judgment to plaintiffs on 240 cases based on assumptions. We don't even know, for example, in Nazario, the ladder in Nazario was set up properly, and it still fell over. And this court found that there was an issue of fact. Here we have a ladder that was admittedly not set up properly, but there's no evidence, or at least reasonably disputed evidence, that that ladder moved at all, that it fell over. And that's the key here, is that there's no proximate cause because there's disputed evidence that the ladder that the plaintiff was using.
So the scenario you're arguing that might have been the factual scenario is he's on the ladder, it's propped up against the wall, it's not open, just closed, propped up against the wall. He gets the electrical shock. He's thrown off the ladder, but the ladder doesn't move at all. He's just thrown off himself.
Right.
Right? Okay. And so the argument there is that even if he had had a safety device, that would not have made a difference?
It's that
Is that what you're saying?
Even if he had...
A different safety device, my
Right.
apologies. The ladder is a safety device.
If he had a ladder that was opened or could have been opened, he still could have fell off. As I mentioned earlier, the recent case in the First Department, 188 AD 3rd 596, the court there cited Vukovic, very similar fact pattern, except the plaintiff was on a scaffold. First Department said, well, a scaffold's not enough because he fell off the scaffold. They're using an electric shock as a means of skirting around the requirement that a plaintiff prove a violation and that the violation was a proximate cause of the accident. And that's contrary to all the other departments, and it's contrary to this court's ruling in Nazario. And that's why I believe that the decision in order of the first department below here should be reversed.
Thank you, counsel.
Thank you.